do the paper shuffle up here, excuse me. Now is the time set for oral argument in cause number 1, CACV 150571, Francine v. ARMENDARIZ is the way I was going to pronounce it. How are we doing?
Correct, Your Honor.
Thank you. Versus Mohave County. For your information, these proceedings are being both audio and video recorded today, so barring any problems with the technical aspect of it, you can critique yourself on YouTube in a couple of weeks. I am obligated to tell you that. Counsel, each side will be entitled 20 minutes, as I'm sure you will not be surprised to hear, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to preserve any of your time for rebuttal, please let us know. We will try not to take all your time, but ultimately it's going to be up to you to reserve that rebuttal time. We've reviewed the briefs, we've conferenced the case this morning, so we are well aware of the facts and issues that are attendant to this argument. Just recognize that in the course of your oral argument, please. And counsel, when you come to the podium, I would ask that you state your name and who you represent. And with that, appellant's counsel, it's all yours.
Your Honors, may it please the Court, Daniel Benshaw for the appellant, Francine ARMENDARIZ. And given the statement that you reviewed the materials and are familiar with the working facts, I'm going to dispense with a factual overview and go into what we consider probably the key issues before the Court, at least in our assessment. The core of this appeal is about the governmental immunity issues, in appellant's opinion. I offered my interpretation of the trial court's ruling in the opening brief. I understand that the appellees have a different interpretation. I'm not entirely sure what the correct one is, in all candor. However, at the end of the day, we get past the duty issues, which, as to Ms. ARMENDARIZ, who was on a county road, Butch Cassidy Road, I heard an acknowledgement that there's a duty to keep the road reasonably safe for Ms. ARMENDARIZ. So in that case, I mean, there is a duty. We also believe that there are genuine issues of fact on the issue of compliance with the standard of care. I guess we need to sort through whether the trial court intended to consider compliance with the standard of care issues as part of the duty analysis. I'm not entirely sure. But if you look at the facts of record, we acknowledge that the appellees have facts that would seem to be in their favor, but still there are contrary facts that go in the favor of the appellant. And negligent summary judgment is so rarely granted on the issue of negligence. And with the facts at record here, the competing facts, we don't think compliance with the standard of care is an issue. Certainly it wouldn't be appropriate for summary judgment. Some of the things that go to that.
Well, let's talk about the immunity issues, all right? Sure. And let's start talking about the absolute immunity. Do you believe that? Well, I'll start with a factual question. Was there any indication that Mohave County has ever signed an easement?
Not that I've seen. There are certain questions posed at different times. One was in the email exchange between Steve Latowski and one of his staff members about whether they'd even inspect County Road.
And you're talking about the email. Well, I have an email chain here, but it looks to me like, is this the email that generated the 2011 study?
It was in connection with it. It's in the appendix.
Okay. So you have no evidence that they have ever signed an easement. Is there any indication that they have ever even studied whether or not they should sign an easement?
In that connection, you have the meeting minutes regarding the California Drive issue in the Valley Vista area. And all that results of that is questions are posed. And they're going to talk with the county attorney.
To their lawyer.
To their lawyer. And then we don't have a resolution of that. And we don't get documents produced when we request it, and we don't get documents that evidence the resolution of that. That's exactly the kind of non-decision that wouldn't qualify.
Well, wait a minute. What happened, if I understand the California Road, What happened is they ultimately signed it, but only after they had accepted the road for maintenance.
There was evidence in one of the depositions of that. In response to the written discovery, it was indicated that didn't happen. But yes, you're right. In one of the deposition transcripts, they said the road is ultimately accepted and it was signed.
Counsel, I'm sorry.
I was just going to ask you, so in what led up, the email chain that was in the record that led up to what I understand to be the 2011 study, and correct me if I'm wrong, how the genesis of that study was the homeowners association wanted or believed that there needed to be signs on Butch Cassidy Road. So they sent a letter to the committee, they sent an email saying, we think you should do this. And Mr. Letowski sends an email forwarding the homeowners association email saying, yeah, we should study this. But they say, I'm going to read it to you, for other signs on the roads that we do not maintain, which would be the easements, suggest the homeowners association obtain the registered engineer to recommend placement of signs. So even in this study, he recognized that we'll study the roads we maintain, they need to study the roads that we don't maintain. Is that pretty much consistent with your interpretation of what you had below?
No, with respect, it's not, Your Honor. There was that discussion in the email, but there was also the question posed about the same time about whether they would inspect intersections with non-county maintained roads at all.
Where was that discussion contained in this record?
And in general, and I'm going to talk while I'm looking through it. If you look at Appellant's Appendix, page 22, it's an August 1st, 2011 email exchange between Steve Letowski, Monty Wilson, and Tim Walsh. And Tim Walsh, on August 1st, 2011, says, Steve, just to make sure I'm clear, we want our forces to look at all intersections on Butch Cassidy from Santa Fe Ranch Road to Mesquite for signing, including intersecting roads we do not maintain.
Okay, and that's a question mark.
That's in response to what I read to you.
Yeah.
And he was saying, we'll study. It says we'll follow up with Mr. Buck. We'll study on the maintained roads. Tell the homeowners association to do their own study. And then Mr. Walsh's response to Steve was, I'm not sure what's going on. Tell me what to do. And he says, okay, we'll talk about it. Right?
Exactly. We'll talk about it.
And then when they actually did the study, what did they study?
They studied the roads that were listed.
Were maintained by the county.
That were maintained.
Which is consistent with what his original direction to Tim and Monty on this issue, right?
Well, I think that there are questions raised because of that question mark. What exactly they decided and they discussed.
Okay.
But you can't say that. I'm sorry.
No, go ahead.
You can't say that contradicts the Letowski comment. I mean, the indication is he's not aware of what the policy is. Letowski said we don't sign roads that aren't dedicated to the county or given over to the county. Correct?
Well, that would seem to be reflective, the Letowski comment, of sort of the past precedence, past practice you see in the depositions. They've never done it. And so, yes, that would go into those kinds of comments. But we submit respectfully that mere past precedence, we've always done it, without evidence of the consciously balancing of risks and advantages as required by the construing case law is not sufficient decision that's been made. This is the one, there's nothing in the meeting minutes. There's nothing in any of the board resolutions that we've seen. There are no policies or procedures. There's an absence of why they do this, which is part of the requirement.
But I've read all of the cases you cited. And the cases involve, for example, Galante, Goss, and the others. And in those cases, there truly was a complete absence of decision-making. Here, albeit perhaps, here's the record that comes to us on summary judgment, albeit not well documented and perhaps informal, the record we have is that the county had a policy of not signing non-county maintained easements, utility easements at a minimum. And there was just no disagreement to that. And I don't think a question mark suggests a issue of material fact. So that was their policy. They did it on a long-standing basis. They followed that practice. So there is not an absence of decision-making, is not, well, perhaps documented in formal minutes, but they did, or it did have a policy or a practice. I don't see any facts in the record that dispute that.
This is different from some of the cases you mentioned,
right,
like Goss and Galati, in the sense that there's some evidence of some level of a decision having been made. I mean, I understand that. We have the deposition testimony. The precise analysis here is whether we have the sufficient kind of decision having been made and whether there are issues of fact regarding that. And whether fundamental governmental policy is at issue. So what we're doing is we're applying the statutory language and some of the case law principles to the evidence of record in this case, whether there is a sufficient form of decision to qualify under the governmental absolute immunity statutory provisions.
Well, before you go on, and I'm sorry to keep interrupting you, but I just want to make sure I understand your argument. You said that whether there is a material dispute on the facts, but that's why I started off by asking you, is there any evidence in this record that they've ever signed an easement? Is there anything in this record that would indicate that this informal policy that Judge Norris mentions has ever been applied differently to this case?
I'll respond again the same way. No, not that I'm aware of, but that isn't the only kind of evidence that can create a genuine issue of material fact here.
Because I went to, the next sentence in your statement on this email chain, he does ask the question that you asked, but then he says, the other intersection in which the county doesn't maintain either roadway would be his responsibility to hire the engineer. Would those recommendations also need to go before the TSC and the BOS? So, I mean, even he understood, wait a minute, it appears to me that he's saying, that's not something we normally would do. Is this something we're going to start doing? I mean, he's wanting direction. And so it seems to me that based on this email chain in the deposition, they're saying we have never done this.
Well, I know, but I think that's too narrowly framing the issue. The mere fact that they've never done it does not mean that there is a sufficient decision that has been made.
But doesn't Glazer address that? I think it's Glazer. The case addressing the fact that it can be a longstanding policy that has been consistently applied and basically, my word would be kind of inerrantly applied. They've been consistent in the process that it's recognized as being a decision of the legislative prerogative, if you will, that we're not going to do this. Do you know what I'm referencing? Do you know what I'm referring to?
I know what you're referring to.
But isn't that the follow-up? Whether they have it in writing, whether they've all stamped off on it, whether successive supervisors have signed it and accepted it, they have a policy that has inherently been applied. As Judge McMurdy says, we don't have one example of their deviation from it, and don't we have case law that says that's good enough?
Well, I think you've got to go back to the statute too to look at what happened here. Well, first of all, there's the evolution in we don't have any. There's the evolution in the depositions in terms of what they say about this policy. At first, I never heard any discussion of it, and then we hear different things as we go along. But the statute is very clear. There needs to be an exercise of administrative function. The legislative immunity. I think this is really an administrative immunity question here. What happened at the traffic control study level and the traffic safety committee minutes? There needs to be an exercise of administrative function and a determination of fundamental governmental policy. And that's right out of the statute.
But are you saying that there has to be a signed, stamped statement of policy that you have to be able to flip to a book and open it up and say, here it is, we don't sign roads that aren't signed over to the county? Is that what you're saying?
I'm saying there has to be, if we're talking that there has to be a determination of fundamental government policy, there has to be some formality attending it. You can't
How
just
much?
Yeah, that's my question. How much?
Well, it needs to be recognized somewhere on an ongoing basis, whether in traffic safety committee, in meeting minutes, some kind of expression, exercise of administrative function. Not just stuff that's talked about in the traffic safety committee office.
But can it be recognized at every intersection of a governmentally maintained road with a non-governmentally maintained road where there's no signage? Can it be recognized in that fashion?
You mean in terms of past practice, or?
I'm saying that can it be recognized in the fact that you can't give us a single case where they've deviated from the plan?
That obviously is a fact that doesn't help us.
Because?
What's that?
It does not help us because?
Because it's one example of where there wouldn't have been a policy. But we think, on that count, we think there are other issues here. The absence in, meeting minutes, things like that. No policies, nothing along those lines that would demonstrate that there was a formally adopted decision that consciously balanced the risks and advantages.
Well, you keep saying formally, and I'm not sure I'm there yet. I mean, you might be, but you may be right.
Yeah.
But it seems to me that in administrating the general policy of the county, that the administrators have the authority, and under our case law, to implement some type of informal policy. Would you agree with that or not?
There needs to be evidence of its implementation.
Okay. And evidence would be, we would look around to see what it is they're doing. And that's why I started off right from the beginning is, have they ever deviated from this, what they're claiming, what the county is claiming, is this informal policy? And if there's been no deviation, isn't that lend support that this informal policy has been adopted?
It's support for the position in that regard, yes. But we still believe that the absence of evidence of a decision which consciously balanced risks and advantages, namely, why is this policy in place, isn't anywhere to be found.
Well, doesn't that go to whether or not this specific sign should have gone up, rather than whether or not they've adopted the overall policy? Because we're talking about a lot of roads in Mohave County, are we not?
Well, there are a lot of roads, yes.
Right. Well, easement, I mean, based on what I'm reading in the deposition. So they've adopted an informal policy countywide. Do they still need to make that specific determination for this particular easement?
No. I mean, I was thinking more broadly that the general decision on this particular subject matter needs to be supported by evidence of having consciously balanced risk and advantages, consultation with city subject matter experts. That necessarily lends itself. Costs. I mean, any number of things. That necessarily lends itself to something more than just, we've always done it that way. And that's a basic position. I'm getting close. If I could just spend a moment about the 820.03 issues. In the first place, the affidavit of Jim Lee that was provided as part of summary judgment proceedings was not timely disclosed. It was months late. We objected on that count. Prior to that, there had not been anything of record that specifically addressed the 820.03 language. The focus of that affidavit is on the 2007 county board resolution that initially accepted part of the roads in that area into the county road system. It does not specifically address the 2011 study, which we submit is a plan and design which supplanted what may have occurred in 2007. Jim Jeffrey, appellant's expert, devoted a substantial portion of his report to the failings of the 2011 study. There's no evidence of any change or circumstances or conditions from 2011 to 2012. We submit that reasonable inferences could be made that the site The site was not in conformance with generally accepted engineering or design standards at the time of the 2011 traffic control study. We recognize that Mr. Jeffrey does not parrot the language of 820.03, but the basic elements are there in terms of unreasonable design and configuration, dangerous condition, and the county has a burden of proof on this 820.03. In addition, we believe that Mr. Jeffrey's opinions demonstrate a genuine issue of fact regarding the presence of a unreasonably dangerous condition. There's no dispute. There's no warning that was provided. So even if the 0.01 provisions applied, we believe that Armendariz's claims survive under 820.03. And I'll reserve the 53 seconds I have for rebuttal.
Thanks, counsel.
Good morning. I'm Nicholas Aceto, and I'm arguing today on behalf of Mohave County.
Can you talk to us about the formality necessary? Can you address that for us and then take your argument, I guess, where you want to? But I'd really like to hear, coming off of what Appellant's counsel said, talk to me about the formality necessary to make this something that the county can rely on as policy.
Sure. I think the case that you were trying to think of is Mortensen, which said that you don't need a formal written policy to establish an affirmative decision. I think that informal policies, longstanding practices, more importantly, where all of the evidence only shows that this is the way they went about government, that is sufficient. You don't need to have something written, signed, and sealed, and plaintiffs' counsel has admitted that you don't need something that formal. This is a government. There's departments and divisions and committees within those divisions. There's a lot of people working on these things.
Okay, so take me down one step.
Sure.
From it doesn't need to be written, signed, and sealed. Take me down one step.
Well, Mortensen is also an unreported case decided in 2015. It was on a completely different set of facts. I don't find relying on an unreported case very useful.
Sure. Well,
can you help me?
Anyway.
I'm sorry, did you have
No,
something
I
you
just,
wanted to
this is an observation. I was not persuaded by a memo decision.
All right. If you take that down that one step, it doesn't need to be signed and sealed and delivered and whatever else you said. What is the next step down from that then?
I believe an informal policy is enough. When you look at all the deposition testimony in this case, in conjunction with the email from Mr. Latosky, it shows that there was a long-standing, well-defined policy that the county did not sign private roads or private easements, and that is enough. When everybody who's making the decisions and conducts the studies are of that belief, and there's ample evidence in the record that there were discussions that this was a policy, that this is the way that it was always done. That is the unrefuted evidence in this case. And maybe in some other case, you really need to walk that line and figure out where's the cutoff. But here we don't have that. We don't have a dispute that this was in fact enough. What I've heard from plaintiffs' counsel is that, well, there's other evidence, that there needs to be other evidence, but he hasn't identified what that other evidence is. The only evidence in the record is that from the Director of Public Works, Mr. Latosky, on down, they all believed and they all testified that this was a policy of Mohave County.
I'm going to call you on something, because you just said they all testified, but I didn't see in this record a deposition of Mr. Latosky.
That's correct. There were only depositions of Mr. Walsh, Mr. Hambry, and I believe Mr. Whalen. Mr. Latosky did not testify or did not give a deposition. Plaintiffs did not take his deposition.
He was noticed for a deposition, was he not?
I don't know that for certain.
Okay.
But his email speaks for itself, as you pointed out. When I read the email exchange, he was merely pointing out, look, conduct this study. If there are private easements, because we do not sign private easements, you're going to have to let the folks in the Homeowners Association know that. And Mr. Walsh's response email confirmed what the policy was. Okay, just to make sure, we're still going to conduct this study on Butch Cassidy between Juniper and Santa Fe Ranch Road, but we're not going to actually take the next step and look at site obstructions or use of those private easements, because that is not what we do. So I see the emails as being consistent, and Mr. Walsh was just confirming what the policy was, and obviously the email chain goes on and says, let's talk about it, but the depositions confirm all of that.
Well, if Mr. Latowski was so set in his belief of what a policy is, why was he making reference in the minutes about California Road?
Well, I think the minutes reflect that policy. Plaintiff's counsel had said, you know, maybe there needs to be something in minutes. Well, the October 2011 minutes do reflect that policy from Mr. Latowski. He says, in response to a request to sign California Drive, which was not a county-owned road, he said, well, I'm sorry, that's not our policy, but maybe here are some things we can do, and one of the things is go petition to get that road county-owned, and then we can talk about it. So
wasn't there an additional option that he outlined that perhaps does suggest that maybe the county might consider
admittedly,
signing?
it's what it says is, well, let's see what it says here. The county may consider installing warning signs at county-maintained intersections at California Drive, advising motorists of no ingress-egress, easement, or right-of-way should such, i.e. easement, not exist. And the should such, i.e. easement, not exist is underlined. My interpretation of that, again, is you have to convert it from a private easement to a county-owned road, and in that instance, we can consider signing the intersection. I will point out also that this is after the study. It's 2 months after, so I think it's relevant to the extent that it's reinforcing and ratifying the policy that they don't sign private easements in conjunction with the fact that there's no evidence that they had ever done that before the study or before the study. But it is evidence to that extent, and I think it's enough evidence. And going back to your question, Judge Jones, I believe that is enough. That's all we need in this case are consistent testimony by the people who handled this study, all testifying that there was a policy. And it doesn't need to be necessarily be on a piece of paper. Again, this is government. Not everything is signed, stamped, sealed, and delivered. People have to operate under directives. And when the evidence only shows that there was a policy, that is sufficient, particularly in this case.
Thank you.
I didn't hear plaintiff's counsel go beyond anything in his briefs on some of the other topics he raised in his brief, but I'd be more than happy to answer any questions that the panel has pertaining to the opening brief.
Could you go? I wanted to call up the traffic study minutes that we were just discussing from October 13, 2011, at pages 168 or PDF pages 168, 169, I think, in the appendix to the opening brief. The third option: the county may consider installing warning signs at county-maintained intersections at California Drive, advising motorists of no ingress, egress, easement, or right-of-way should such ingress, egress, easement not exist. What do you think the underlying language means then?
I think that means that should an easement not exist means that easement has to be converted into a county-maintained road. So you've got one county-maintained road with a private easement. We can sign that intersections if that private easement is converted into a county road.
That's building on the prior option number 2, which is residents who can petition to extinguish the easement.
That's correct.
Okay.
Unless there's nothing further, I have nothing else.
Thank you.
Thank you.
Just briefly, and that's all I have. Anyhow, looking at that same language again, I don't interpret it the same way. The county may consider installing warning signs at county-maintained intersections at California Drive, a private easement, advising motorists of no ingress/egress easement or right-of-way should such ingress/egress easement not exist. This is express acknowledgement of the possibility of of regulating the intersection of a county-maintained road and an easement.
Well, let's assume for the moment, forgive me for taking this a little bit longer, let's assume that your rating is correct. And so there is an option floated, a possibility. How does that avoid summary judgment? When you have all the evidence here that the county had a policy, perhaps not formally documented, that it did not sign these type of easements, it operated consistently on that policy based on the evidence we have throughout, and the fact that maybe someone threw out a trial balloon of, well, maybe, that doesn't denigrate, diminish, or destroy the existence of the policy, does it?
Well, it certainly creates an issue as to whether that policy was in place respecting an intersection of a county-maintained road.
But how can raising a question create a triable issue of fact that they didn't have a policy? I mean, I don't understand how just raising a rhetorical question, at best, with that construction, could somehow get to the jury on, if this is a jury issue, on the existence of a policy.
Because here he's citing the possibility of doing the very thing they claim the policy doesn't permit him to do.
But if you say that, then, I mean, taking that to an extension, if a governmental entity has a policy, the fact that they might or it might wish to consider a change or a modification or
Amendment.
an amendment would mean then they couldn't do that, because they would then lose the immunity rights they had based on that policy. Government would be at a standstill, wouldn't it?
Well, I think there's some weight that needs to be given to the acknowledgement of a possibility. If it's as firm a policy as they say it is, that just wouldn't be something that would be considered at all. And it's just additional evidence that there are issues of fact.
Oh, wait a minute, and you're eating up some of their time, so you're good.
Okay.
And we just want to make sure that we understand it. If they have a policy, and let's say they had a formal policy written down, the fact that later on they want to amend the policy, or they're saying, oh, you know, we might want to explore this, does that mean that even the formal policy then is no longer a formal policy?
I'm not trying to evade your question, but we don't have a formal policy.
I know, this is a hypothetical. That's what we do here.
No, that would be different if there's a formal policy in place that's actually documented and demonstrates conscious balancing of the risks and advantages. I mean, that's different. That meets the statutory criteria for immunity. I think it's entirely different where here we've got water cooler level type discussions that we don't do it, we never have, as opposed to it being discussed or adopted in any other more formal setting. I think that these kinds of issues after the talk about the possibility of not following such a policy are very pertinent, because I think it's the less formal it is, the more vulnerable it is, and we're supposed to construe these immunity statutes narrowly.
But you have more than a water cooler discussion going on, where you've got, where you're able to provide us with no examples where they've deviated from that water cooler discussion, and at best there's this kind of this postulate that's put up there. What if we were to? And from that we assume that all of the consistency that has gone into their practice in the past is washed away as far as proving what the policy of the county is?
No, I think it feeds into the overall argument and intersects with the overall argument that there wasn't a conscious balancing of risks and advantages with respect to this asserted policy, and that this is more of an example that it was never anything that was sufficiently adopted according to the dictates of Arizona statute.
Thank you.
Thank you for your time.
It's the issues that actually make this job enjoyable. Gentlemen, thank you. We were looking forward to this today, and you haven't let us down. We appreciate your argument. We're going to take it under advisement at this time. We will rule in due course, and we're adjourned. Thank you.